Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. Yesterday, the 26th of March, 2025, the Clerk of Court in Ada County released a number of public documents onto the record in Idaho versus Koberger, and this next filing is one of them. It is a reply to the state's response to defendant's motion in limine number 3 regarding the use of the term, and it's a 6-letter word. It begins with the letter M for unaliving. But before we get into the substance of this document, received some feedback questioning, wanting to know, what does in limine mean? In limine is a motion in limine, seeking a pre-trial ruling, usually on the admissibility or inadmissibility of evidence, to prevent disruptions and possible prejudice during the trial itself. Some of the motions in limine have literally dealt with words. What words can or cannot be used during the upcoming trial, and this one is no different. Comes now in this reply, Brian C. Koberger, Brian through his attorney of record, and hereby replies to the state's response to, and this is the defendant's motion in limine number 3 regarding the use of the term M for unaliving, filed with the court on March 17th, 2025. Going on to page 2, the defense continues and says, Mr. Koberger's motion, that means the motion in limine, seeks to exclude the state in its case presentation. That means the case in chief. That means what's also called the guilt phase of the proceedings, as described in Judge Hippler's October 9th, 2024 pretrial and trial order. So again, Mr. Koberger's motion seeks to exclude the state in its case presentation from using any form of the word M for unaliving, and then in bold letters, as it applies to him. His request is based on his constitutional rights to a fair trial and due process of law, as well as the Idaho Rules of Evidence 403. And then there's a footnote here saying the Idaho Supreme Court in State versus Ellington assessed the word, quote, another unaliving beginning with the word H on an exhibit. There the court found the trial court had not analyzed probative value of the use of the word H on the diagram, and the court did not see probative value. Its use as an exhibit was an abuse of discretion, according to the defense's recitation of Idaho Supreme Court precedent set forth in State versus Ellington. Mr. Koberger, this reply continues. In his motion, again, that's the motion in limine regarding the use of this M word for unaliving by the state in the case in chief only, specifically stated that it was not the use of the word itself, but of the phrasing of the word that labeled him. Mr. Koberger has maintained his innocence since the day he was accused. His objection is about referring to him as the M word with an ER at the end. To allow the state to present its case by labeling him as one is improper and inflammatory. This will be the ultimate jury question. In other words, is he guilty of 4 of the 5 first-degree felonies that he was indicted on that deal with the M word as it relates to the 4 students? The 5th charge is for first-degree burglary, a felony as well. The defense then says this will be the ultimate jury question. The jury must not be prejudiced by making a decision based on influence, labels, and inferences of what the state opines, of what the state's opinion is of Mr. Koberger. In other words, ladies and gentlemen, this is dated the 24th day of March 2025. Ann C. Taylor has signed this on behalf of Mr. Koberger. You can review the document by going on to the docket. It was filed on the 24th of March, and now we await the hearings on all of the in limine motions and Judge Hippler's ruling on this motion, as well as all of the others that remain pending. This is Kathy. Thank you for joining us here today.